Welcome to our fifth online lecture. As you probably know by now, this fifth online lecture is also being accompanied by a part in-person lecture. So if I am going quickly through these things, it's probably something we've touched on in class. So this is what we left off with last week, which was a list of the way that the test developed. And now we're back to a sort of clear and present danger test for being that outer bounds of the First Amendment free speech protections. And what I left you with last time was this way to look at the test, which is kind of a three-step process. And I have now given you the worksheet to start to fill in some of the cases and some of the general rules as we go along. So the first step is looking at what type of speech is at issue. The second is what is the government regulation. And finally, the effects of that regulation. So what we'll be dealing with today is the time, place, and manner restrictions versus content viewpoint restrictions. Because depending on which one we're talking about, that may vary the tests that we use. Why are we looking at these specific cases? Because these are, not all the cases to be sure on the First Amendment's free speech protection. Well, these various contexts kind of help show the bounds and the boundaries of free speech. So if we look at things like symbolic speech, we can look at a broader question of whether non-speech is treated the same as speech under the First Amendment. And if we look at public forums, we know that people say, well, this is a public place, I have the right to free speech, but is that necessarily true at all times? Hateful and offensive speech, is it protected? Student speech, are students entitled to the same protection as adults in public? Commercial speech. I have told you before that commercial speech enjoys some protections, but not all. And what are those protections? And then finally, associative speech. When is association a form of speech under the First Amendment? So by looking at these areas, we should be able to start to develop general rules so that if I were to present you another case, you'd be able to determine whether or not there's a constitutional violation there. So let's look at symbolic speech. The United States versus O'Brien case has to do with someone burning a draft card during a Vietnam protest rally. And the question is whether the burning of a draft card is protected symbolic speech. To be sure, the draft card was burned because of a specific reason. It was saying something about that entity. But can the government punish the burning of a draft card? Well, let's back up. What is the speech involved? The speech involved is the burning of a draft card. Let's claim it's symbolic speech without going much further right now. And is the regulation that we're talking about, so step 2, what is the regulation we're talking about? Well, this is a regulation involving laws that provide for the selective service, provide for the draft. So these are not laws directed at the content of the speech, but they're laws aimed at protecting draft cards because they are a means of tracking individuals for this governmental purpose. So, although the speech may be symbolic, the regulation has nothing to do with the speech. It's almost incidental to it. So, therefore, the government can punish under this regulation. So if we look at the test that the court gives us, we have kind of 4 things we need to answer. 1, is the regulation within the constitutional power of the government? Here, the regulation has to do with the draft, so it is. It's pretty much spelled out in the Constitution. 2, does the regulation further an important or substantial governmental interest? The draft, presumably, furthers the governmental interest that is involved with maintaining a standing Army and Navy, which is allowed for. So one can claim, and the government successfully did here, that it does. Third, is the government interest unrelated to the suppression of speech? The government here says it is unrelated to the suppression of speech because they say that no matter how you destroy a draft card, or for whatever reason, let's say it's just neglect, they could still punish you under this law. Now, were they going to punish other people that just neglectfully ruined their draft card, spilled coffee on it, etc.? Probably not. Could they have? Yes. They got away with it here. But the challenge is still open for an as-applied challenge rather than just the text of the regulation itself. Finally, is the restriction on the alleged First Amendment activity incidental and no greater than is needed to further the governmental interest? So this is that effects prong of the speech. Is the effect of the regulation suppressing otherwise protected speech? Maybe it is. Maybe this is something that should be protected. But here the regulation trumps because it is incidental to the speech. So under this test, the government is okay. What about burning the flag instead of the draft card? Well, the courts have looked at this case a couple of times. The Texas versus Johnson case is whether burning an American flag at the Republican National Convention is symbolic speech that is protected, and the court found that it is protected. This has to do with a Texas statute about desecrating the flag. Congress tried to have such a statute. The court struck that down as well. And they set forth the test for symbolic speech. Okay? And so symbolic speech or expressive speech is speech that, or are actions that are sufficiently imbued with the elements of communication. But really, it's whether you look at that and see an intent to convey a certain message and the likelihood that that message was conveyed. So burning the flag in this instance was intended to convey a message, and you cannot, as the government, restrict the conveyance of a message. So this test that they set forth, first, you must determine whether the act constitutes expressive conduct that implicates the First Amendment. Essentially, is it symbolic speech? And here, according to these things on the right side, the court said, yes, this is symbolic speech. So you move on to the next part of the test, because this is protected speech now. Then you must determine whether the state's regulation is related to the suppression of free expression. In other words, is this time, place, and manner, or is this content or viewpoint based? If this is time, place, and manner, or if this is something else entirely, like protecting the draft, then you use the O'Brien test to look at this. If, however, this is a government, if this is not somehow unrelated to speech, if instead it is very related to speech, then you have to ask whether the governmental interest justifies a conviction under strict scrutiny, so compelling governmental interest in substantially related means. What the court is saying here is very important, and some people say, well, you shouldn't be allowed to burn the flag. But the court is very careful to talk about the ways in which we actually do burn flags. And in fact, the statutes are always careful to say, this is not banning you from burning flags that are, for example, no longer fit from service. Because if a flag is no longer fit for service, what is done? You burn the flag. Now, granted, it's a different kind of fire, but the flames themselves are the same. It's what you intend to do that is different. And so the court says you can't change your mind about the act because of the reason why it's done. And so under Texas versus Johnson, you can burn the American flag. So if we were to include this in our test, it goes in that first box there, includes symbolic speech. And we could even actually add a little bit into that second box about the test for viewpoint based or content based regulations. Let's turn to public forums. What is it about public forums that gets people thinking they can say whatever they want? If we need go no further than our first case of Schenck to know that you cannot yell fire in a crowded theater. Well, Chaplinsky is a different case, and it involves someone who actually is doing kind of street preaching. It's a Jehovah's Witness who's preaching on the street. And there are altercations between him and other people, and eventually the police shut the whole thing down because there's a brawl. He yells at the police. There's some obscenities thrown towards the police from him. And the question is whether or not the words he uses protected from essentially punishment, but protected from governmental regulation. And what the court says is that the First Amendment is not absolute. First Amendment rights to speak are not absolute at all times. And they set up this idea that the government may regulate time, place, and manner of speech. And so time, place, and manner of speech aren't related to the content or the viewpoint of the speaker or even the identity of the speaker, but related to just the time, place, and manner. So these things may be appropriate in another time or another place or another manner. So taking that a step further, and this involves a bit of symbolic speech. It's written, but not in a normal way. The Cohen case, Cohen versus California. A young man decided to wear his leather coat into a courthouse, and on the back of the coat had a taped message using, I believe, duct tape, that said, "Fuck the draft." And an officer saw this. No, he wasn't disturbing anybody. He was sitting in a courtroom. An officer saw this, tried to get him arrested in the hallway. One of the judges didn't want to hear it, and so he brought it into another courtroom and tried to get him arrested for breaching the peace. And the breach of the peace was not that he was causing a scene. Actually, it was the officer really causing the scene. It was just merely the coat. So whether a coat that says "fuck the draft" is protected in a public courthouse. And the court said yes, it is. There was no conduct here other than the words themselves. There was no fighting. There was no trespassing. He wasn't causing a brawl in a public place. He was merely there with a message on his back. The government cannot bar certain words. It may not like them, but it cannot bar them. That's what the First Amendment is all about. That's content regulation. And so you cannot bar someone from wearing a coat that says "fuck the draft." That's a First Amendment violation. So we have two public forums here. We can put these points of law into our tests under that second part, the purpose of the regulation. The burning of the flag is a viewpoint-based regulation. Obviously, burning the flag for a reason other than showing disdain for it was allowed. But time, place, and manner gets us around some of that, and the Chaplinsky case can fall under that. The Cohen case would also fall under the viewpoint of the speech or even the content of the speech. So we have a content, a viewpoint, and a time, place, and manner to show you how that works in practice. But what about other public forums, like, let's say, outside of an abortion clinic? Well, that's what came to head in Hill versus Colorado. Although the state of Colorado wasn't so narrow in their thinking. The regulation at play in Hill versus Colorado prohibited people around any medical facility from engaging in protests within 100 feet of that facility. 100-foot radius, all medical facilities all across the state. In addition, there was an 8-foot moving radius around each person entering and exiting the facility that you couldn't approach them with things. The reason that this might be important in an abortion setting is because people often try to do what is called street-side counseling, where they will literally walk up to the person walking into the clinic and try to persuade them otherwise. So this is an issue for an abortion clinic, but you could actually see it being an issue for other types of clinics as well. And certainly abortion clinics are not the only medical facilities where there have ever been protests. So the question is whether these regulations, which the state is calling time, place, and manner regulations, are not time, place, and manner, but content or viewpoint based. So the anti abortion advocates are claiming these are content based. Where else would these be in play? And the state is claiming no, these are time, place, and manner. And the court sides with the state. And it's important to understand why the court sides with the state because we had a case just last year that came down a little bit differently. So the court sides with the state, and they say that this is a time, place, and manner regulation. This was not adopted because of the content of the speech, although they had noted in their legislative history that there were some violent actions at abortion clinics in the past. But they talked about what the state's interests here are. And the state's interests here are just as important, they felt, as the First Amendment interests at play. Although you have a right to try and persuade people not to do something, and you have a right to voice your opinion and protest certain things, the state also has a right and an interest in providing access and privacy to healthcare facilities. And they also have a need to provide police with guidelines as to what's appropriate protest activity and not. And by drawing this 100-foot radius, they drew something that wasn't so broad as to say you can't come within 3 miles or, 300 yards, which is, much larger. But they drew it as narrow as they could while still achieving the same goals. So the general thing to take away from this is that to determine neutrality of a regulation, when you're talking about time, place, and manner, the test is whether the government has adopted a regulation of speech because of a disagreement with the message it conveys. And here the state said, no, actually, regardless of what you're saying, whether you're pro-abortion or anti-abortion, we don't want you within 100 feet. We want you out of that way. This is an access to a medical clinic issue. So the court agreed with them. Now, Massachusetts tried to pass another law, and they had very good reason to. And after the shootings in Fort Springs in Colorado at a Planned Parenthood clinic, many clinics want stronger protections for both their patients and their workers. But the Massachusetts law had a wider radius than 100 feet. I can't remember if it was 1,000 feet. It was significantly larger. And it just did not meet this standard. And so it was struck down by the court. So we can add in the Hill case under time, place, and manner as to what constitutes a valid time, place, and manner regulation that is neutral. One of the areas that people have a lot of trouble with is this idea of hate speech. Sometimes they have trouble with it because it seems, well, we do have hate crimes. But it's important to note that the hate crimes we have are always attached to another crime. It is not a crime, for example, to yell racial epithets or to just be plain offensive in your language. It may not be appropriate. You may get kicked out of places. But as long as you're not getting kicked out of a public forum, then you're actually not running afoul of the First Amendment. So when is it that the government can regulate in terms of offensive and hateful speech? The RAV versus City of St. Paul case gives us an element of kind of a little bit of despair in some ways. We have a case where someone broke apart a chair. It was two teenagers. That's why we have the case initials as opposed to a name. RAV are the initials of one of the defendants. And they decided to make a crudely built cross out of it and burn it in the front yard of an African-American family. This certainly has the effect of being intimidating and is a very strong symbol out of a very dark time in our nation, one that is continuing very much to this day. And we have to understand that that can be true. It can be a horrible symbol, but that doesn't mean the court can allow it to be regulated. Under the First Amendment, what the court says is that a statute, like the St. Paul Bias Motivated Crime Ordinance statute, which made it a crime, a specific crime, to do things like burn a cross in someone's yard or draw a swastika on someone's garage or anything of that nature. That was the crime in and of itself. These dumb kids were not charged with vandalism. They weren't charged with trespassing. They weren't charged with any of those things. They were just charged under this statute. And this statute was entirely speech-based. So if you look at your book, it talks about, it gives you the language of the statute right there, and the statute talks about what is appropriate and not appropriate speech. And while it may be coming from a good place, the court says you cannot regulate speech based on content. The statute is viewpoint-based. And they say it's viewpoint-based because the viewpoints here are deemed to be unacceptable. Probably for good reason, they note. But it is certainly viewpoint-based. And when government regulations are viewpoint-based, they have to be necessary, not just compelling, but necessary to carry out an important governmental interest. So we're talking something in the time of war, that type of level here. And while people may argue that racially motivated hate crimes warrant different types of action, the court says, according to the First Amendment, that they don't. So, the Snyder case, Snyder versus Phelps. This is not Governor Snyder, although people may have hateful language in Flint to him these days. But this is not that Snyder. It's a different Snyder. The case involves the Westboro Baptist Church. If you don't know who the Westboro Baptist Church is, I'll save you the Google, although you'll probably do it anyhow. And these are the people that protest military funerals and any kind of celebrity funeral or mass shooting victim funeral because they believe that America protects gay people and therefore is doomed to hell because of it. And I'm not sure where their protests fit in, but that's their religious beliefs. And it is led by someone named Fred Phelps, or it was until he died. His daughters, or one of his daughters, now runs it. They protested, as they do, a military funeral, and the father of the fallen soldiers saw the protests on TV later. Even though they were kind of cordoned off 1,000 feet away from the church, in what is typically called the free speech zone. They protested at this church, and they had signs specific to the church, enough that it was a Catholic church, and they had signs that were specific to Catholicism. They had at least one sign that used the soldier's name, I believe his name was Matthew, and said that he was burning in hell. And the father saw this, had significant health problems after that, had a, you can imagine having your son die in war and then having to endure these people and catching them on the evening news. You didn't see they were there before because people usually block the view, which is nice. But so he sued. He sued for intentional infliction of emotional distress. And the Phelps defended that suit by saying this is our First Amendment right. It's our First Amendment right to protest at this funeral because it involves a public, not a private manner. So although the speech is hateful and offensive, beyond moral redemption, it does have a First Amendment value according to the court because they weren't just talking about the subject of the funeral. They were talking about the military, and they were talking about the government, and they were talking about social matters. And so, therefore, it's public. Speech is public when it can be considered to be related to any manner of political, social, or other concern to the community, or when it is of a legitimate news interest. And the court said, sadly, that fits here. People can beg to differ on this. Some people did. In fact, Justice Alito noted that there was a lot of this that was not necessarily public but still occurred anyhow. But they had enough public speech mixed in with their private speech to make it at least acceptable for First Amendment purposes. So if we add those in, we can talk about what is and is not protected speech, whether it's public or private. We can also talk about the viewpoint of the speech and the content of the speech. So this escapes regulation, not because the regulation is trying to be content-based, but because of its protection under the public speech doctrine, but also the viewpoint of the speech in terms of hateful or offensive speech. So when we're looking then into splitting these up into two different tests, the time, place, and manner test says that regulations are acceptable where the government shows that the regulation serves an important non-speech related objective and the means are narrowly tailored to achieve that end. So important non-speech related objective. That's essentially like a heightened scrutiny, but not a strict scrutiny basis. However, the content-based or viewpoint-based restrictions are only acceptable where the government shows that regulation is necessary to serve a compelling governmental interest and is narrowly tailored to achieve that end. So if the government is trying to regulate content or viewpoint, it has a much higher burden than if it's trying to regulate time, place, and manner. So when we get into a case, what you'll often see is the government saying time, place, and manner, time, place, and manner. And the courts have to decide whether this really is time, place, and manner, or whether this is content or viewpoint based. We will continue this next time. I know I'm dragging a little bit of this week's material into next week's lecture, but I think it's a good place to stop. We'll talk about student speech, commercial speech, and association, and we'll also talk about libel, obscenity, and that whole bag as well. So we will wrap up there, and I will see you in class.